Hello, friends. We welcome you to the Legal Breeze. Today, we will be discussing a very important topic which is not only rocking the nation, that is, Government of India, our country, but it also has a global and international ramification. The magnitude of the problem is so high, it involves several sovereign functionalities cutting across countries, boundaries, all these things. By this time, you would have guessed the issue. Yes, perhaps you may be right. The issue which we would like to discuss with you is the spyware. Pegasus spyware. What is the implications? I will not be talking about politics, but I will be strictly confined my discussion only with the legal aspects. First, the constitutional implications. Second, the other legal implications, including what procedural change which we need to make in the Criminal Procedure Code, Indian Evidence Act, etc. Then, as a way forward, what is the international law? How international law is affected by this, and how international law can provide solution. These are the issues I would like to discuss this. First, what is the constitutional implications? First, this spyware. No, you know there was the telephone tapping has led to the lot of dispute between the center state issues in India. There was a government which has been dismissed by using 356 during Rajiv Gandhi's days, I think Hegde government. Even Rajiv Gandhi made an allegation against Chandrasekhar that he was tapping him, not by way of telephones, of course, by with the help of policemen. He is being spied. Various allegations. The landmark ruling is Amar Singh case. The Amar Singh case has made a substantial contribution in the regulation of legal interception. Currently, there are two pieces of law which governs the legal interception. One is under the Telegraph Act, another is under the Information Technology Act. Section 5, by this time everybody would have known this particular provision. Section 5 of the Telegraph Act and Section 69, 69A, all these things dealing under the Information Technology Act, which allows the government, subject to certain procedural safeguards, that the government is authorized to have the legal interception. Or they can spy or they can tap, whatever you may call it. But this is totally different. Now, this is tapping. And this tapping, unauthorized access, espionage, whatever you may call it. This is not sanctioned by law, first of all. And this is wholly unregulated. This is very important. So what constitutional implications it may create? First, it will create center state problem. Now the state police may spy upon the central police. Central police may also spy upon the army, other wings. The civilian establishment also use this software. Unfortunately, this may create a lot of administrative chaos. This is one aspect. If everybody started using this particular software, and if it falls into the hands of a terrorist, what will happen? It is not that now you may say that you are spying the terrorist. If it is available, because once you make a technology can be replaced by another technology. And many of the terrorists are so good, they are very skilled. So they may develop a technology, or if the technology falls into their hands, what will happen? This is very unfortunate scenario. Second thing, for the individuals, which affects not only the right to privacy, freedom of expression, even the mere thought that you are under surveillance, your entire life is gone. The fear psychosis, it's very unfortunate. It gives you a feeling whether you are living in a free democratic society or otherwise. That's the question. Everybody's conscience will be shocked the moment you come across these sort of news, because many individuals have been targeted That's what the news report says. I'm going only by the media. I'm not sure. But some of their phones have been tested. That's what they say. And they say it is found positive. The trails are found. But there is a good, say, in forensic, you cannot, no criminal, however his talent, he will leave some evidence. Thanks to the existing data regime, international data regime, that the data can be stored elsewhere, not within your country. There is a cross-border exchange has taken place, and whatever happens, the Google will have its own repository at US, its headquarters, like that. Facebook, WhatsApp, whatever it is, they can have. Apart from that, the organization which has developed this Pegasus software, NSO, can also have its own repository. Even that may, NSO may also try to erase it, but it cannot erase the entire thing. The data could have been stored elsewhere. So the international community, when they come together, I think they can strongly and effectively deter these sort of issues. The next issue is, what about its evidentiary value today? Because entire forensic evidence needs to be thoroughly checked. The Indian Evidence Act, though you may have section 65A, 65B, all these things under the Indian Evidence Act, maybe you may have 45 to 48 and 48A, something like that, expert opinion relating to cyber or cyber forensic evidence, something like that. Already we have got this malicious use of this phone with the help of malware, which we have discussed in one of our previous video, in the case called Bhima Kariham. There is an apprehension that there is a popular labor lawyer, Miss Sudha Bharadwaj, has been caught under this, and she is still in jail without getting bail, unfortunately. So with this software you can manipulate the evidence like anything. You can implant any document, anything, without the control of the particular owner of the phone or user of the phone or user of the device, whatever you may call it. It is very unfortunate. Then this 300 people list in India, it cuts across all branches of the government, including constitutional functionaries such as opposition leader, the election commissioner, the judges, sometime, many things. So what it sends a message. So we need to thoroughly check this. And if the government says that the government has not done, that means, are you not able to control law and order? That means, are you admitting there is a failure of constitutional machinery in preventing these sort of unauthorized intrusion into your own citizens, which has happened in your territory? Can you keep quiet? That is another important ramification arises. Now let us come back to the international law. Now many international conventions need to be revised, including Vienna Convention on the diplomatic privileges and immunities, consular privileges and immunities, because this for the software can intrude into anybody's device without any support from the user. People call it a zero-click attack. That's it. Just by a mere miscall, a message can be helpful in causing infection to your system or device, whatever you use it. So many international conventions needs to be checked. The protection given by those conventions have become quickly outdated. So that those conventions need to be thoroughly checked, revised, amended, updated, so as to face these emanating challenges. The next issue is dual technology. It's very important. We have certain convention relating to nuclear treaty. These are called dual use technology, because nuclear energy can be used for creating power, generating power, and it can be used for destroying the life with the nuclear bombs. So that's way. So we have chemical convention, biological weapon convention. Like that, we should develop a comprehensive convention dealing with the application of dual usage technology in the information technology domain is concerned. So this software is also strictly subjected to various export control regime from Israel, but still it has been proven that there is an end user monitoring agreement is also that's what people say, there is such a class, but these have been proved ineffective. We understand even people in US and some of the negotiators, that means they are diplomats, their phone have also been infected. So if not here, France has already started taking the steps. I think the US will also do such a similar exercise. And above all, in the interest of use of doing business, in their own business, entities such as WhatsApp, Google, Facebook, because when they say that their system is safe, whether it is Android or iOS, whatever applications, now they have to, some of them have already started taking legal actions in the United States. So we hope, if not done by in India, elsewhere justice will come and will offer some kind of consolation. But equally, I don't underestimate our Supreme Court, because Supreme Court has given effective remedies to face the challenges arising out of COVID very recently. To preserve the independency of our constitution, integrity of our constitution, independence of various constitutional entities including the EC, judiciary and other things, I think we need to thoroughly investigate and remove the fear in the minds of the citizens. That's very important. Otherwise, people may even fear to touch the smartphone. And how will you promote the ease of doing business? How will you promote the digital economy? That goes very objectives of this particular government. At least in their own interest, I think government should come forward. Not only the government, all the constitutional stakeholders, including the citizens, should take a proactive approach in finding out the truth behind all these things. And international community, under the platform of, there are certain international alliances on the cyber issues is concerned, I think UN should also take an effective role, lead role in developing a comprehensive convention so as to deal or combat these sort of misuse of this technological weapon against the innocents. I hope the good sense prevail sooner rather than later. God bless you all. Thank you. Jai Hind.